been accumulating ever since the Charles River Bridge case, not long after Munn versus Illinois, attained to a point at which they began to grasp many important prerogatives of sovereignty, and to impose, what was tantamount to, arbitrary taxation upon a large scale. The crucial trial of strength came on the contest for control of the railways, and in that contest concentrated capital prevailed. The Supreme Court reversed its attitude, and undertook to do that which it had solemnly protested it could not do. It began to censor legislation in the interest of the strongest force for the time being, that force being actually financial. By the year 1800 the railway interests had expanded prodigiously. Between 1876 and 1890 the investment in railways had far more than doubled, and during the last 5 years of this period the increment had been at an average of about $450,000,000 annually. At this point the majority of the court yielded, as ordinary political chambers always must yield to extraordinary pressure. Mr. Justice Bradley, however, was not an ordinary man. He was, on the contrary, one of the ablest and strongest lawyers who sat on the federal bench during the last half of the 19th century, and Bradley, like Story before him, remonstrated against turning the bench of magistrates to which he belonged from a tribunal which should propound general rules applicable to all material facts into a jury to find verdicts on the reasonableness of the votes of representative assemblies. The legislature of Minnesota in 1887 passed a statute to regulate railway rates, and provided that the findings of the commission which it erected to fix those rates should be final. The Chicago, Milwaukee and St. Paul Railway contended that this statute was unconstitutional because it was unreasonable, and the majority of the court sustained their contention. Justices Bradley, Gray, and Lamar dissented, and Bradley on this occasion delivered an opinion, from which I shall quote a paragraph or two, since the argument appears to me conclusive, not only from the point of view of law, but of political expediency and of common sense. Quote, "I cannot agree to the decision of the court in this case. It practically overrules Munn v. Illinois. The governing principle of those cases was that the regulation and settlement of the fares of railroads and other public accommodations is a legislative prerogative, and not a judicial one. This is a principle which I regard as of great importance. But it is said that all charges should be reasonable, and that none but reasonable charges can be exacted, and it is urged that what is a reasonable charge is a judicial question. On the contrary, it is preeminently a legislative one, involving considerations of policy as well as remuneration. By the decision now made we declare, in effect, that the judiciary and not the legislature is the final arbiter in the regulation of fares and freights of railroads. It is an assumption of authority on the part of the judiciary which it has no right to make. The assertion of jurisdiction by this court makes it the duty of every court of general jurisdiction, state or federal, to entertain complaints of this nature, for all courts are bound by the Constitution of the United States, the same as we are." End of quote. There is little to add to these words. When the Supreme Court thus undertook to determine the reasonableness of legislation, it assumed, under a somewhat thin disguise, the position of an upper chamber, which, though it could not originate, could absolutely veto most states touching the use or protection of property, for the administration of modern American society now hinges on this doctrine of judicial dispensation under the police power. Whether it be a regulation of rates and prices, of hours of labor, of height of buildings, of municipal distribution of charity, of flooding a cranberry bog, or of prescribing to sleeping car porters duties regarding the lowering of upper berths, in questions great and small, the courts vote upon the reasonableness of the use of the police power, like any old-fashioned town meeting. There is no rule of law involved. There is only opinion or prejudice or pecuniary interest. The judges admit frankly that this is so. They avow that they try to weigh public opinion as well as they can, and then vote. In 1911 Mr. Justice Holmes first explained that the police power extended to all great public needs, and then went on to observe that this police power or extraordinary prerogative might be put forth by legislatures "in aid of what is sanctioned by usage, or held by preponderant opinion to be necessary to the public welfare." A representative chamber reaches its conclusions touching preponderant opinion by a simple process, but the influences which sway courts are obscure, often, probably, beyond the sphere of the consciousness of the judges themselves. Nor is this the worst, for, as I have already explained, the very constitution of a court, if it be a court calculated to do its legitimate work upon a lofty level, precludes it from keeping pace with the movement in science and the arts. Necessarily it lags some years behind, and this tendency, which is a benefit in the dispensation of justice as between private litigants, becomes a menace when courts are involved in politics. A long line of sinister precedents crowd unbidden upon the mind. The Court of King's Bench, when it held Hampden to be liable for the ship money, draped the scaffold for Charles I. The Parliament of Paris, when it denounced Turgot's edict touching the corvée, threw down the gate by which the aristocracy of France passed to the guillotine. The ruling of the Superior Court of the Province of Massachusetts Bay, in the case of the writs of assistance, presaged the American Revolution, and the Dred Scott decision was the prelude to the Civil War. The capital essential of justice is that, under like conditions, all should fare alike. The magistrate should be no respecter of persons. The vice of our system of judicial dispensation is that it discriminates among suitors in proportion to their power of resistance. This is so because, under adequate pressure, our courts yield along the path of least resistance. I should not suppose that any man could calmly turn over the pages of the recent volumes of the reports of the Supreme Court of the United States, and not rise from the perusal convinced that the rich and the poor, the strong and the weak, do not receive a common measure of justice before that judgment seat. Disregarding the discrimination which is always apparent against those who are unpopular, or who suffer under special opprobrium, as do liquor dealers, owners of lotteries and the like, I will take, nearly at random, a couple of examples of rate regulation where tenderness has been shown property in something approaching to a mathematical ratio to the amount involved. In April 1894 a record was produced before the Supreme Court which showed that the state of North Dakota had, in 1891, established rates for elevating and storing grain, which rates the defendant, named Brass, who owned a small elevator, alleged to be, to him in particular, utterly ruinous, and to be in general unreasonable. He averred that he used his elevator for the storage of his own grain, that it cost about $3,000, that he had no monopoly, as there were many hundred such elevators in the state, and as land fit for the purpose of building elevators was plenty and cheap, that any man could build an elevator in the town in which he lived, as well as he, that the rates he charged were reasonable, and that, were he compelled to receive grain generally at the rates fixed by the statute, he could not store his own grain. All these facts were admitted by demurrer, and Brass contended that if any man's property were ever to be held to be appropriated by the public without compensation, and under no form of law at all save a predatory statute, it should be his. But the Supreme Court voted the Dakota statute to be a reasonable exercise of the police power, and dismissed Brass to his fate. The converse case is a very famous one, known as Smith v. Ames, decided 4 years later, in 1898. In that case it appeared that the state of Nebraska had, in 1893, reduced freight rates within the state about 29% in order to bring them into some sort of relation to the rates charged in the adjoining state of Iowa, which were calculated to be 40% lower than the Nebraska rates. Several of the most opulent and powerful corporations of the Union were affected by this law, among others the exceedingly prosperous and influential